formal. So given that it's 7:05, we're lacking a formal quorum, but we will proceed forward with the meeting agenda, and other than with the minutes we'll skip over. So we have a few members from the public. If you'd like to speak at this point, you're welcome to. Otherwise, any contributions can certainly be given as we go through various discussions for different items. And I know, Spencer, you had been a part of a discussion that had been occurring regarding other bylaws. If you'd like to discuss any of that at this time, you're welcome to do so.
Sure. Yeah, Spencer Brennan. I'm resident Wakefield on Wave Ave. So I wanted to bring in the attention to the bylaw about snow and ice removal, and my thoughts around it being that it should be considered a town-wide initiative for all residents, not just commercial and multifamily zoned properties. The town has invested a lot of money recently in sidewalks, and it's a very walkable town for most of the year, winter being that exception. And when the majority, a large portion of the town just refuses to shovel all of their sidewalk, they'll do, from the driveway to the walkway, and then neglect everything else. It makes walking around town and to and from schools very difficult. So that's what I would like to bring to the bylaw committee. Thank you.
So thank you. Very, very helpful. As part of the lead up to this, Spencer did write to the committee. I am happy to forward that off to anyone who wishes to see the dialogue. And as a part of that, I did help engage the DPW with this. So Joe is aware of it, and he's also bringing in Dennis Fazio, who's in charge of the sidewalk portion of that plan. Because amongst the questions is what happens with the new sidewalks that have recently been constructed. How is the determination made as to what sidewalks the town plows versus not? Apparently there are three devices that the town maintains for snow removal of sidewalks, and there's an orchestration that happens for that. So those discussions, Joe is more than happy to meet with us and with Spencer to go over any different pieces. And DPW is responsible for the implementation of snow and ice. So unlike anything else, any other violations in town, DPW actually is ticketing authority in Wakefield for snow and ice violations. At the moment, the current bylaw, which was revised in 2018, only applies to properties that are used commercially or large multifamilies, more than 4 units. And part of that at the time was being driven by the thought that getting individual single family home owners to vote in favor of a mandatory removal with fines and other things that can happen could be difficult to pass at town meeting. So there was a political decision that factored into the componentry. In addition, it was a expansion to make it a town-wide requirement, including all curb cuts. So that was new to the bylaw in 2018. Previously, it was only certain sides of certain streets, predominantly in the downtown area, and there was no effective enforcement because it was only able to be enforced by police. So if there are thoughts on continuing that expansion to make it town-wide, certainly happy to hear other opinions on this, and to what degree we should move forward in terms of exploring it. And this is not the end of the conversation, this is just the beginning.
Dan, I think we would also have to entertain, we'd have to bring in town council for this. I remember these conversations when I was on it, and part of the concern was the feeling of taking the pulse of the town to see whether they would vote for regular single-family houses being fined, and how does that look? And, you know, what is the mechanism to do that? So I think it's a great idea, but I do think we would need to reach out to, in addition to DPW, just the town council for the penalties and the money assessed, which would come under them.
Good comments? Other thoughts? And Spencer, by way of background, Anne is a former member of the town council. She spent, was it 9 years on the town council and board of selectmen? So many years in the executive branch before effectively retiring, at least for now, from that, and now joining us on bylaw review. So again, this is just the beginning of a conversation. It can certainly continue on, and I expect that it will. So I genuinely do appreciate any and all dialogue with people on various issues, and this is one that we have been actively seeking feedback on, as the implementation is fairly new. It wasn't actually adopted until 2018, and then we haven't had a snow season like 2015 since, so we haven't been able to really test it and see what the appetite is if there are property owners who are grossly delinquent, as we had seen previously, where they would just leave it, and in some cases, especially if there were vacant properties, they just wouldn't touch any of the components. It also changed a little bit with the SJC ruling, where homeowners are now liable if they take no action. It used to be where if you took no action, you just left the snow, then a homeowner wouldn't be liable, it would be deemed an act of nature. SJC, Supreme Judicial Court, came out with a ruling a few years ago that flipped that on its head. And so now homeowners can be liable if you take no action. So it depends upon what the requirements are. So it is something that is very ripe for reconsideration. So I think it's safe to say, watch this space. More's coming. To borrow some language from Rachel Maddow for that. Anything else from public engagement? Okay, so the minutes from the prior meetings on December 18th and 29th. My apologies, Lucy, for not getting the minutes from December 18th out immediately. I just missed that email and didn't put them into Dropbox for evaluation and approval at the last meeting. So those have now been sent to everyone, along with the January 29th meeting. Getting it at the next meeting is not a problem. Within 3 meetings is what the expectation is, and they are available in draft form if anyone should request them. Okay, moving right along. This brings us over to the big item of the night, zoning bylaws. So we have Attorney Mark Bobrowski joining us from Danvers, normally from Concord, but today he's in school over in Danvers until he has to leave in about an hour or so. And so we can leverage that. At our last meeting, there were a lot of items that we had that we wanted to continue we want to have as interactive discussions. And so I think it would make sense to probably start with some of those items, and we can continue from there. Does that seem like an appropriate approach, Attorney Bobrowski?
It does. Thank you, Mr. Chairman. Well, I'm looking at your email to me dated the 29th, which was also, looks like it was copied to the committee. I'm going to use that as my outline.
That's fine. It actually was copied to the general committee address just for records keeping. It was based upon notes that I'd taken at the meeting itself. So it covered a few items. If you can just explain what those items are as we're discussing, I will set up a share so people can see what the items are as we're discussing them.
That's great. Okay, so this is a series of comments on sections 1 and 2 of the zoning. And I think just to start our discussion tonight with that, I think this is a great place to start going back through the first draft, which is now complete, and making a real thorough review of these piece at a time, if you will, so that we can put a second draft together that is accurate and reflects comments to date. My recommendation for the next meeting, and I'll remind you of this as I get up to go to the town meeting floor here, would be to, let's just do the use table. One item agenda, the use table, from soup to nuts. The only other thing I would add to that is potentially the new definitions that I've sent in a separate file, because there are many that correlate with the use table. But that would be, I think, a huge benefit and a good use of our time for the next meeting or the meeting after that. I know that you want to talk about the MBTA stuff, Mr. Chairman, coming up shortly. So the first comment was the fifth bullet, if you will, to mitigate and reverse the effects of climate change and to encourage multimodal. Should these be separated? No problem. I'll just hit the return button and we'll add another bullet and we'll fix that. There is a question about the next bullet. It looks like 2 bullets down. To embrace and encourage racial, cultural, generational, and socioeconomic diversity. And the question I was asked is, are these normally common in updated zoning bylaws? Answer, no. I've not seen anything like that. I'll just cut to the chase, and I think you should probably substitute the relevant item from the 2030 vision, which is the zoning welcomes, or that we could restructure the sentence. But the goal is to welcome and support residents in different life stages and inviting people of all backgrounds. I think that is certainly something which doesn't raise a flag. A lot of sometimes in these zoning provisions, you see a lot of code words. I think Medford and I just went through this looking at things like neighborhood character. What does that mean? They actually changed that to indicate that it would be focused on the building design rather than, more subjective qualities of a neighborhood, like who lives there. So I think that's the kind of change that would wear well. And what you've got here in the 2030 vision plan would be substituted for that bullet as it stands. Stop me if you have any questions or you want to discuss this.
And so this was an item of significant discussion at the last meeting. Thoughts for those who have been a part of this, and for those of you who haven't, and this is new, your input is also certainly valued and appreciated.
Dan, so I agree with Attorney Bobrowski. I think based on certain court rulings, I would be very hesitant to include, to embrace and encourage racial, cultural diversity. I think it makes us a bit of a target. And I believe the statement from the 2030 plan gets at the same idea with less flag raising language.
Nicely put.
I tend to agree with that assessment as well. And this is where having members of this committee that have different backgrounds, we're able to coalesce information from different parts of the town, and I think bring it together. Part of this is to make sure that the language is relatively timeless, knowing that many of these bylaws haven't been looked at for at least 40 years. The language, we want to be meaningful, but we also want it to be able to be lasting. And the language that was found in Vision 2030, I think, gets to the point of being welcoming without having to state other items. I think that it would not be unreasonable to suggest to the town council that elsewhere there be a position, or possibly even the planning board, that there be a more explicit type of policy statement that gets to the bullet point on embracing, encouraging racial, cultural, generational, and socioeconomic diversity. I think is a goal that is certainly a laudable one. I just don't think that it should be codified here. I think that as a policy statement, it can then be expanded upon, modified on a more practical basis. So that's my 2 cents. And I'm also very cognizant about trying to give people undue standing in an issue where that they may not otherwise have standing. And this way it keeps the language fairly generic, and I don't see that as being something that, if we use the language from the vision statement, welcomes and supports residents in different life stages, that's something that I don't think a court would say automatically gives standing. Whereas I could see a court possibly going on if someone were to say that they felt along one of the 4 specific items that they had standing. So that's just my 2 cents. I'm not a lawyer, but I've learned how to interact with lots of lawyers, given that on my Zoom screen, I'm surrounded by 3 of them. Other thoughts? Okay, next item.
There was a question about the necessity of section 1.4 scope. And I looked at it again, and I read it in conjunction with 1.5. They're pretty close to saying the same thing. I don't know that the scope provision is absolutely necessary. I don't think it does any harm. It is an attempt to just frame the topics that are regulated, and applicability makes it more personal. Like if you're doing any of these things, you have to submit yourself to the bylaw. So I think it's 6 of one, half dozen of another. If you want me to strike and renumber, I don't have a problem with that, but I don't think it does any harm. I think they basically say the same thing from a different perspective or context.
And part of the discussion that we had was given the density of the bylaws as is, if there's the ability to remove unnecessary components, let's again remove it if it's not actually adding value. Where things add value, we absolutely will want them. If it's not going to add value, then I think that it's best off being removed. That's my 2 cents. Others' opinions?
Is that a vote to strike it, Dan?
That's a suggestion to strike it. We can't actually take votes. Well, we can't take binding votes, but yes, my recommendation would be to do that.
Okay. We did remove the fees, and you'll see a lot of strikeout to that effect. I believe it's way down below there.
It's right in here. 190.73 is the current section.
Right. And so the original thinking I had, which I think I explained in a marginal comment, was that these are clumsy to put these into a bylaw, because if you want to change the fee for cluster development from $70 to $90 per dwelling unit, you got to go back to town meeting. And that's a pretty cumbersome affair, especially if you're trying to do something which requires quicker action. You're not going to do this but once or twice a year. And it may be that you've got fees in here that you want to raise on a faster basis. I just basically don't see fees in bylaws that often. So that's the reason that I struck them out. The question was, can the fees be retained in the bylaw? Yeah, they were in your other bylaw. I can put them back.
So the the summary of the discussion, at least my interpretation of it, is given the nature of how open town meeting works in Wakefield, which is different than representative town meeting and different than other towns, is that when it comes to fees, the town meeting is extraordinarily reluctant to increase fees and to give carte blanche ability for any other entity to raise fees. As Anne Shirley remembers from her time on town council, whenever fees were proposed or discussed, it generated a significant amount of discussion amongst the town if it was a increase of any substance. If it was a complete decrease, not much of an issue. But if it was an increase, it definitely generated discussion. By the same token, there were some areas in here where it made that this should be simplified, where it should just be the monetary piece of the fee and nothing other than the monetary component be in the requirement, so that way all other requirements are subject to the hearing body as to what might be required for submission, how submissions have to be processed. But the town has actually had discussions to increase these fees, and they were struck down repeatedly at town meeting. And it was not, to put it bluntly, the vote really wasn't very close to strike it down. Where it required 2/3, I think it was about 75 to 80% against the increase of fees. And while the town certainly is always looking for ways to get revenue, fee structures is not one that the town meeting participants tend to be particularly amenable to. That's my take on it. I know the others here have been to plenty of town meetings, and your opinions are certainly encouraged.
Well, they're certainly cheap, Dan. I'll give you that.
My gut would say take them out, because the inability to edit the fees, except for going to town meeting, seems to just be overly difficult. And when fees are raised outside of the bylaws, they're always looked at to be consistent with surrounding communities and what are the best, not best practices, but what are what are the fees that Reading or Melrose or Stoneham has. And we found so often that we were charging somebody $10 for something that was consistently maybe 30. And it's not so much about trying to make money off of our residents, but a lot of it is, when the fees were laid out, just administratively sometimes, what does that cost? But I mean, I agree with Dan. Fees can be a tinderbox. It just seems to me to have fees in a place that we cannot revisit them except through town meetings seems to be a little daunting.
I think fees of this type, administrative fees, ought to reflect the actual cost to the municipality of accepting and processing and then shepherding the special permit application, for example, through the process. And it's not $100. It's the very typical fee these days would be $300. And that's more representative of the actual staff person's time on a prorated on an hourly basis to get the job done. You're losing money here.
Joe, your thoughts?
Dan, so last week I was on the fence, either way on this. I guess thinking about it, could you still, I guess, take the price out, but just explain that there is a fee for these items so people aren't blindsided by it? Is that an option? I mean, have you ever seen that, Mark, at all?
I can certainly do that. I would want any list to be all inclusive. And I can go through this and just, I mean, just
I don't know,
eyeballing here and
it just seems like there's a lot of information there, and I understand the fees go up. So then you'd have to change this part of the bylaw, but if you just took the price out, at least you wouldn't have to, you wouldn't have to change the prices. You could just, do that somewhere else, I guess, but.
I could keep a kind of running list here of the things that require a fee, and by the time we're done with 5 drafts of the bylaw, I'm sure I'd have the vast majority of them in the list. I just wouldn't want to leave anything out and then have to face the consequences that you didn't list it.
No, and the other thing that Brian brought up too last week was like the 25 copies down below. It says, you need
That
to.
needs to come out.
Yeah, so I mean, we could either take that out or, adopt it to today's standard, which is PDF. Again, I mean, I was talking about this last week about, how, at least when people come to this bylaw, they know what to expect and not go to the building department. Now Gil has to tell them, explain to them that they have a fee for this. They have to present 25 copies, or they have to get a PDF. At least if someone's on, looking up online, they know kind of somewhat of a, they have a heads up on what to expect when they come down to the building department. That was just my thoughts.
Amongst the comments that definitely came across last week was a separation of the dollar fees, so the pecuniary components, versus all of the process. The process definitely needs to come out because that needs to be set by each board, whether it's the zoning board of appeals or the planning board or town council, wherever things need to be submitted, they need to set up their own process. And it could be that we do a different designation. From a political perspective, and this kind of gets back to the earlier discussion that we were having about snow and ice, is that if we remove the fees here, it does strike me that it will get picked up on that this would be viewed as a subverted way to allow administrative control over fees, and that could actually make it extraordinarily difficult to get the recodification overall approved where it requires 2/3 vote. So that may be something that comes effectively in a phase 2 is the removal of the fees. I just look at it if there's a change that it was only a few years ago, I think 3 or 4 years ago, where there was a request to increase these fees. I'm not sure if you were on the ZBA at the time, Joe, when that came through, but that failed spectacularly at town meeting, just because it was built based upon the surrounding towns and the cost could be explained and justified, but the town meeting participants were not interested in increasing the fees for this type of development. So that's just where I'm looking, trying to balance. My input is to try and balance the approval process with things that are known to be sensitive. And in this town, there are a few topics that tend to be really sensitive. Anything that involves the word parking or garage. I know Brian is probably ready to run as soon as I mention those 2 words, or money. So those are the 3 things that before anything else that tend to get politically, those are the tinder boxes in this town. You can, if we want to talk about, foliage, we're talking about the use table. I don't think that there will be all that much large scale interest in it. But as soon as you start talking about parking, money, or garages, you're going to put things at risk. That's just my 2 cents. Anne?
See, I don't care if we put it at risk. I know you do, but I don't want to be held hostage because a small group of people with loud voices argue against something that makes sense. We're not talking about usurious fees. We're talking about the administrative ease of changing things when necessary. And I totally get what you're saying, Dan, but I wouldn't not do it because I was afraid of town meeting. But you have more experience with getting this through. I also think the town has changed a little bit in the last few years. I don't know.
Others' thoughts?
The sense I'm getting, Mr. Chairman, is that I should probably put back the paragraph that says, in addition, the following fees shall be paid. And I can put it back in with the numbers. And like I said, we got 4 drafts to go here. It's not gonna take anything for me to whack it out.
I also like the idea of having a combined list of all fees that are related to zoning. Because if there is a decision to move it, then, or remove it, whether it's now or in the future, it then becomes a singular place for people to go. And that, I think, gets to what Joe was talking about, which is we want to make it reasonably easy for someone to know, okay, this is what we're trying to do. We want to encourage development in the town. As long as it's smart development. And I mention that because that's a significant part of the reason for zoning, is it's appropriate land use.
So my takeaway is that I'm gonna, looking at the top of the page as you see it, save some of that introductory language. I don't think that fee to cover advertising and notification, that's not enough right there for any newspaper today. So I would
It's definitely not,
like
if those fees can be somehow segregated out, so that it could be that some of the, dare we say, legacy fees
Yeah,
that are listed are here, and then there are additional fees that can be assessed by the boards for their administrative components, including applications. And so those types of direct costs can be correlated. But again, someone knows, okay, there's going to be a cost for for applications, for advertising notification. What those costs are is going to be based upon what the costs are at the time.
right, it's just the actual cost. So I'll just clean that up and take the numbers out. And then in the next paragraph, I'll keep that as is, and I'll stop where it says submissions to zoning board.
That seems to be consistent.
Okay. I don't know that this belongs in section 1, but I'll figure that out when it may belong in section 10.
Okay. We will look for that.
Okay. All right, the next one was in section 221, Mr. Chairman.
Okay, and as we're just getting ready there, Eric, do you have audio? It looks like we will be able to call the meeting formally to order. But it does require audio for us to be able to do that. So Eric, if you've got audio, if you can let us know, and then we can, in the meantime, we will continue on. So section 2 in the discussion of the districts, and I know there's some other discussions we'll want to get to as a part of this. So amongst the things that came up was 221 on the districts that were being proposed.
Yeah, and this has specifically to do with the assisted living facility overlay district. So we had talked a couple of months ago about putting in a more generic provision for senior housing, which would include independent living, assisted living. It would also include long-term care facilities, and finally congregate facilities that have one or more of those pieces as a component. The change over to a senior housing facility is not a district, it's a thing. So it would be a thing allowed in certain districts, and thus it would be reflected in the use table as senior housing facility. And then you'd run the columns and you'd have yes, no, special permit kind of thing. So that strikeout there is if you're going to buy the concept of a senior housing facility instead of just an assisted living facility, which is a very narrow view of senior housing. I mean, generally assisted living is a way station on the road to long-term care facility. And it usually follows a period of independent living. It's really a pretty brief period of time for many people going through the transition. So that was the thinking with senior housing facility. So that would come out, the reference to the district, and then the reference to the map, which may be in 231. If you scroll it down a little bit. Yeah, you can see I also struck number 6. And for that reason.
So amongst the items that we discussed, the concept of senior housing, I don't think that in of itself has been problematic. It's more of we do have a facility that is using the assisted living overlay, and we would want to make sure that we're not putting that any uses that are being done, especially where there's changes to density and parking and other components. And yes, I did say parking, which we know is a lightning rod, but those items that are otherwise problematic, the assisted living overlay handles, and it handles it in very limited segments of the town. And we just want to make sure that if we're putting in senior housing, it will allow for the appropriate dimension, the appropriate relief, so that we don't have a building that has to exist just because of legacy reasons. I think I'm summarizing that pretty well. Attorney McGrail actually represented that particular project, so he has more details on that. So, Brian, if am I communicating that moderately well?
Yeah, my concern on this was historically going back in 2012 and 2014, this whole concept of assisted living, senior living, some folks on the committee or present tonight will remember this was robustly debated at town meeting. There was town meeting votes, there was challenges at the ballot box. I mean, and so basically the way our assisted living is set up, it's a separate section of the bylaw, and it actually incorporates independent living and memory care. So those all come under the umbrella of assisted living. But one of the things and I really don't care either way, but I just want to kind of give the history of this, and it might be helpful to Mark and his consideration on how to go about this. But one of the things at that time, and Ann, you might remember this, was that town meeting decided they wanted to limit the maximum number of independent living units in a assisted living facility, which were allowed there, but limited to no more than 50% of the units. And the theory on that was that the assisted living was going to have less of an impact where these were allowed from a traffic perspective, the naughty word parking and so forth. So they really wanted to kind of manage that and make sure that a number of the units, at least 50%, were going to meet the category under the statutory definition mark of assisted living that needs to be licensed, which includes memory care units. So, and then our assisted living section of the bylaw also gives dimensional relief for these types of facilities, has its own density requirements based on square footage of land that's involved, and has setback dimensional relief requirements for projects of this nature. So those are all included. So I'm all for, doing what Mark's suggesting. I just want to make sure that those considerations are implemented or at least discussed by your committee with eyes wide open on what we're going to propose. Because Mark, with the senior living, were you anticipating it would have like a density requirement that would be listed somewhere in the bylaw, or how you would determine?
I earlier drafts used to have some sort of a formula, but I find it to be just pretend world. I mean, if you propose something that works, and if it doesn't work, it's got to get a special permit. So if there's you're packing 5 pounds of sugar into a 2-pound bag, the answer is no. But otherwise, I'd rather leave the density calculation to the business plan of the proponent of the facility. And I don't think that they're really trying to stuff a lot of people in where they don't belong.
I'm all for that. I mean, I just want the committee to know what we have now, and I don't know if that's gonna cause problems at town meeting when you're changing it that drastically from where we have kind of parameters on that use now, which are gonna be unleashed, if you will.
I would hope that there would be, one of the reasons, again, for lack of a formula, is because I've represented these providers, and they have two different models, really. They have the more urban model of a building with probably just enough room to get the ambulance around the back, or the van to take and pick people up. And then there's the campus style, where this is a Green Acres kind of assisted living facility. And certainly the math for one is not the same as the math for the other. And both of them are needed facilities. Some people will be able to afford the house on Route 2, or the independent living facility on Route 2, where you make the curve at the old mobile station there. That thing was behind trees until they cleaned up that Route 2 improvement. Nobody saw it before. That's one style. But then the same company that I represent has places in Worcester, where they're basically 3 buildings on a block, and different price levels, obviously, as well. So that's part of my thinking. And I've not seen bad results without a formula. I've seen appropriate results.
Brian, do you think that the town didn't collapse and die with Brightview? Like, that was the fear, right? That the Brightview was going to be this.
It was the unknown, Ian, you're right. Yeah, it was the unknown at the time, right?
It was the unknown.
Yeah.
And now Brightview is a wonderful part of our town. And as the town ages, maybe, I don't know, maybe they see it a little differently.
Yeah, I'm indifferent to this. I very much respect Mark's thoughts on this, and that's why I asked. I just, wanted the committee to realize where we are today and where we might go. And I would support that type of change, but, I just don't know that, other people that were involved, because as you know, this was very contentious at the time, would be open to making such a drastic change to that use. That's all.
I mean, the model that I'm most familiar with, that I think between my house and your house has worked the best, is Carlton Willard in Bedford. A wonderful facility, church sponsored. It's got everything soup to nuts. Everything is proportional to the neighborhood. It doesn't have a lot of independent living parking and congestion from traffic. And again, having just gone through this with my 2 parents who went through these various transitions over the last 15, 20 years, independent living is a farce. You're 3 minutes away from assisted living, and independent living is pretty much the same. You're 3 minutes away from memory unit or long-term care facility. So it's not like there's a bunch of 67-year-olds having drag races at an independent facility. That's not my experience.
Others' thoughts? The points that here are, I think, are being well made. And now that we are 10 years later from the heavy discussions, and the facility is built, it's open, it's a part of the community has that experience. And with that, do we think that the community would say, okay, this actually works for the community, and if there's going to be another facility that's being built, it will be subject to special permit, so therefore there will be discussions with the ZBA, and it will need to therefore conform to the neighborhood and be beneficial? Or do we think that there would be enough resistance that it would cause significant problems? Thoughts?
I think
Joe, Lucy?
if there is a shortage in the market here, I think it's an independent living. Right now, I can't reveal any confidential information, but right now I'm looking in Concord for a place to do independent, because everybody has to leave Concord. When you sell your house, what are you going to do? Buy another one? That's not going to work. So there needs to be a place for people to stay and then graduate, if you will, to assisted living after that. So it's a short-term solution. I can't wait if I get the opportunity to propose this to town meeting, because I know that there's just a pent-up demand to be able to stay in the town where their kids grew up, and probably some of them still live.
If I may, Mr. Chair, so two thoughts on this. One, I think any senior, I'm questioning Mark, and I asked for your expertise, but we need to, keep the assisted living overlay district where the current assisted living facility is, to make them be availed to a special permit if they ever wanted to modify their use. Or
They could do
just
that.
let
They
them
could do
become.
that as a non-conforming.
Yeah, that's what I was wondering. So they could just become non-conforming. Okay, thank you.
It's the same permit either way.
Okay, thank you for that answer. And number two, I would suggest you might need to consider putting some parking requirements for facilities like this, at least, because otherwise, I mean, usually if you don't have a density requirement, the parking requirement based on the density is what kind of drives your density requirement, because you got to be able to park a facility.
That's a good thought.
And
I'll see what I can come up with.
yeah, I mean, I don't know how that calculation would be, Mark.
When my mother was in assisted living facility 10 years ago, and she kept complaining when we took away her keys finally. So I dragged her to a Dave and Buster's in the Research Triangle of North Carolina, and I sat her down at one of those machines where you could drive the steering wheel and you put the quarter in and the thing takes off down a racetrack, and she hit everything. And that's the age at which the car no longer is an issue for these folks that are transitioning, because the kids don't let them keep the car.
I think currently, Mark, I think it's half a space per unit.
Okay.
I think it's 0.5 is what's required. And then maybe you can look into if you look in the assisted living bylaw of our existing bylaw, you'll see the parking requirements. And I'm not saying those are right, but those are what people are familiar with. And I think it has a calculation based on the maximum number of employees on top of, it's something like that.
Okay.
Okay.
I think politically, if we put that into, where that becomes part of the definition for senior housing, and then senior housing has a expanded capability across the town, I think that will actually get to the point that you're making and that others are making, which is that we have this need. It allows, if there's a developer that wants to build this type of unit, it then becomes able to do so. They no longer need to have a multi-year process. And to build upon the former problems, they don't want to have to garage the idea. So, and the reason for saying that, Mark, is that there was a proposal for Brightview, which is currently built, to be in effectively the same location, but to also take over another parcel and give the town access to a parking garage. It generated massive amounts of discussion that to this day still has bad blood going in it, and it's just one of those things. We call it garage wars in the town, and it's one of those things that none of us will ever live down. People to this day still say, so where were you on that issue? So that's part of why when we talk about parking being an issue, as a lightning rod, it divided this town in a way that is very, very seldom seen. More so than even like presidential politics. That issue just really did divide it. So along those lines, as we're going through here and we're talking about uses, the other pieces in here that were in the email that we discussed last time was the update of the date itself for the Wakefield zoning map.
I see that, yes.
So that's just administrative. And then the MBTA communities overlay district, we'd like to have a meeting with you, a separate meeting with you to discuss the proposed bylaw for that.
Okay, do you want to do that next, or do you want to, I see a May 19th deadline. How does that fit in?
The idea is that there are two hearings on the proposed bylaw. One is, I believe, next week, and then one is 2 weeks after that. So if we've been requested to have a meeting the week of February 19th,
Okay.
obviously not the 19th itself, because that's a federal holiday, but the Tuesday, Wednesday, or Thursday, preferably Wednesday or Thursday of that week, the committee has expressed availability, so we can get your input on that bylaw as well, because that would be helpful.
I think Tuesday or Wednesday would work, Dan. So if you wanted to poll your members and pick one of the two, I would make it work on my end.
Okay, so we're looking at Wednesday, 21st, 7 o'clock by Zoom.
Is Wednesday the 21st?
Wednesday is the 21st.
Okay,
So
I'm writing that down. Okay.
so
I think that works.
keep that one easy. That also addresses the other issue. The other piece that is related to this tangentially is in terms of overlay districts and zoning districts. Mr. McGrail, I think you also wanted to just make the committee aware of some other things going on. This seems as good a time as any.
Thank you, Dan. I appreciate that. I had spoken to Dan earlier today that I represent the property owner at 50 Quannapowitt Parkway, which is, I think you folks are all familiar with that. It's at the intersection of North Ave and Quannapowitt Parkway. It's a vacant land that's sat vacant for years with rumors of development with multifamily housing that was recently considered there and office buildings in the past. And what they're proposing there now is a modest storage facility, public storage, that would be built in a single building, not a garage type of the units, but a single building that would be situated back along Route 128. And you know, would have a very low impact to the property into the area, because those, as you know, don't generate any traffic. They don't generate a huge need for public services. They just provide tax base for the town, and a much needed use in that area, especially considering the new units that have been built on North Ave and are being built on North Ave, and then the new ones at 200, 400 Cabot and Forbes project on Quannapowitt Parkway. It presents an opportunity to put that land to use. We believe that the building will be situated out back, and there'll be a huge area up front that would be able to be put into a conservation restriction to be landscaped along Quannapowitt Parkway and never be developed in the future. So it's certainly something that has to go to town meeting. We've had discussions with the Friends of Lake Quannapowitt on this. They've been gracious enough to entertain our idea and to get their thoughts on it with anything around the lake, and we're going to continue. We're going to actually meet with them tomorrow night on this. So in order to do that, Mark astutely pointed out in his drafts that we don't have a storage facility use recognized. What has been done in the past is a warehouse use, is the way that the building inspector and Board of Appeals has interpreted it by a special permit. The issue with this property is that it's in the limited business district where warehouses are not allowed. So what we propose to do, Mark, on this is our bylaw is going to utilize, or steal your definition of self-storage facility. The only thing that we're gonna do is edit it a little bit where it says a facility where individual portions of space are rented to consumers. We're gonna change that to businesses or consumers, just to make sure that folks know that it's not just limited to people, but businesses could rent there too. And then for the temporary storage, we think that's a very good definition. And we're proposing to create an overlay district, which would include this land and a portion of the land next to it, the other property owner, because we have a common easement for access. So our access would have to have the use allowed in it too, and that's on the neighbor's property. And then to allow these self-storage facilities currently where warehouses are allowed also. So it would basically be in the business district where they're currently allowed by special permit, and in the industrial districts where they're allowed by right. And then self-storage facility will be allowed in this particular overlay district. So this is something that we're gonna be filing with the town council this week to commence the process, because the owner of that property has made a determination. Now is the time they want to sell that property for use. We've been able to convince them that this is the best use for the property, for the town. When you look at the impacts, as I've already said. So we're gonna give it a shot at town meeting in the spring to see if we can make that fly. And so I just wanted, I called Dan because I've been participating in this process. I enjoyed it. And I didn't want to be filing an article for a zoning change without you folks knowing about it, because I'll be doing that. And I also respectfully wanted Mark's thoughts on this as an expert on, the overlay district, Mark. The reason we're doing an overlay district, I had talked to Dan, and the suggestion was there's not too many other properties that are zone limited business. And why not just make it allowed as a special permit and limited business and not do the overlay? The issue with that is my office park is right on the lake in an extremely big piece of land. And in discussions with some stakeholders on this and preparing for this, we think it would hurt us to do that, because we think there'd be trepidation and nervousness for a lot of people if my office park property were going to be zoned for a storage facility right on the shores of Lake Quantapowhat. And this property is not. It's on the other side of a street separating it from the lake. So that's the thought process, Mark, on why we want to do it as an overlay, but also allow it in other areas that are not near the lake.
Yeah, my first preference would always be to do it as an entry in the LB district, but I understand that if you frighten too many people in too many other LB districts, your chances of success go down proportionally. So,
correct.
Yeah.
I had a discussion with town council on this, and I did some research, Mark. I think where we're going to allow it in other districts, and there would be a good purpose and arguably, and it will be decided and discussed at the planning board hearings, a good public benefit for this project. I don't think it would be subject to a spot zoning claim, and I'm interested in your thoughts on that.
And spot zoning is dead.
Okay.
The case is beginning with the Andrews case from Amherst many years ago, where they rezoned some land into a floodplain district that had flooded once in a hurricane in Amherst. Spot zoning died right there. Then there were a series of Cambridge cases in which any public purpose attending the vote wiped out the older factors that you used in spot zoning, like the size of the parcel, the number of parcels.
Mm-hmm.
That just sort of disappeared. I got my hat handed to me in a case from North Cambridge called Bellis Circle. Judge Foster got it right, and I was still in the past. He woke me up.
Okay, thank you. Appreciate that. So
I'm told that they're on Article 6 or 7 or 8. I'm 9. Wait a minute, here comes one. They're on 8. So I just got my text warning me. Can we quickly pick a date for our next meeting?
So our next meeting will be February 21st.
And are we going to discuss MBTA that night?
Well, MBTA, and we will probably also I anticipate we'll probably start with the definitions or continue on. I brought them up obviously tonight just so that people are aware that they have them. They are posted so that anyone from the general public, it's part of the draft one documentation.
And are we talking about the definitions that I sent you?
Yes, the new definitions.
Can we try to do the use table that night as well?
We can try to, although I think that will probably be chewing off too much. It'll depend upon how much discussion there is around the MBTA. Once you've had time to look at it, if I'll take your cue, I'll put it on the agenda. If you think it will generate more discussion, then we can always defer the use table.
All right, I'll contact you between now and the end of the week or the end of next week to just make sure that we're on the same page. And I'm rushing off to the Article 9 discussion here, housekeeping items at Danvers Town Meeting.
Sounds good, and good luck.
All right,
Thanks,
thank you.
Mark.
Thank you. Okay. So with that positive side, we did get our next meeting done earlier, so we know when that meeting's going to happen. That'll be February 21st, 7 o'clock by Zoom. I will set that up as a posting. I will also add the minutes from the prior two meetings, as well as minutes from this from this gathering. It's not technically a meeting, but it can be treated as such. So there's no harm in doing so, and there is benefit for the public to know, okay, there are items that were discussed. Namely, it was a review of the items from the last meeting that were discussed in more depth. And I do appreciate everyone's input on it because I think we're getting to a much better product. This is a slow and plodding process, but yet an important one too. We're going through the different pieces here. Any other thoughts as we get ready to wrap up?
Dan, it's not a call to order then? It's just like our discussion started at 7:05? I'm just trying to be precise.
I think that would be how I would list it. Brian, do you have any thoughts on that?
Yeah, I just want to say is probably the only consistent participating member of the public. You guys are doing a great job. The process is excellent, and I agree with you. It's going to be a great product at the end of the day. So thank you for your efforts. And it is a slow process, so you're very diligent and conscientious, and it's all going to pay off in the end. Thank you.
So thank you. Appreciate it. Given that some of this language is much older than 40 years, we know that because the last time it was reviewed in depth was about 40 years ago. And a lot of that language predates that. The work that we're doing now really will last. It's generational, and that's significant. To answer your question, Ann, I would do it as a you can probably use the standard language of a meeting, just that if you note on it that quorum was not met.
Already done. Yep. Got it.
Then I think if there's any doubt, it becomes very clear.
Got it.
And as you may recall, quorum is actually defined in our bylaws, where it's not actually defined by state law in this case. So the quorum, it's consistent with the generally accepted definition. So last thing we have, this is actually on the agenda itself. There are a series of upcoming holidays. There's Isra and Mirage, which starts tomorrow evening. We've got the Lunar New Year, Lincoln's birthday, which is coming up next week. So happy birthday to President Lincoln. Can't recall how old he would be, but he'd still fill the top hat. Mardi Gras starts February 13th. So for those of you who may be thinking about going to New Orleans, which is obviously one of the places that a lot of people like to celebrate, but it is a religious holiday in nature. Followed by Valentine's Day and Ash Wednesday are the same day. So you can go ahead and have a very merry Valentine's, Galentine's, whatever suits you as appropriate. And it's also the beginning of Lent. So for those who follow that, make sure that you plan your meals accordingly. And then we have President's Day on February 19th. So that's the reason why the next meeting is not on the 19th itself. It will be on the 21st. So with that, we don't actually need a formal adjournment, but the meeting will conclude at 8:10, I think is a safe way of putting it, unless anyone has anything else. So with that, thank you for your time. Appreciate it. Great to get input from others in the public. Whenever the more input we can get, I think the better. And as Brian said, this is a really slow plotting, but really important process. And all of the comments are greatly appreciated because I see us going back and forth on some of these issues, and we'll need to figure out what the pulse of the town is on some of the components. And I don't think that it's safe to say that we know what those are yet. At this town meeting, we should try to just talk with people, see what they think are the priorities. And as we go to other events around town, what do people think are the dominant components? When I talk to people, I usually don't talk about zoning because that will usually generate a lot of yawns very quickly and people have to excuse themselves. But if I talk about land usage, they tend to get very interesting. What you're allowed to do and what you're not allowed to do on land, what is the role and the limits of the role of local government in determining that. Those are some of the elements that I've found people really do take interest in because that it all affects our livability. Where we all live in town, we're all residents, and this is for the townspeople. So really important. With that, thank you, everyone. I appreciate all of your time, and we'll see you in about 2 weeks.